What happens, though, when your client now is telling you this terrible story of what happened to them, but it's after the 90 days, and this happened in a municipal hospital? It happened at Metropolitan Hospital or Jacobi Hospital. Is their matter still timely? Can they still bring a lawsuit? The answer is maybe. And there is a process that we have where we can actually apply to the court seeking permission for a late notice of claim. It's called filing an application nunc pro tunc, as if it were timely filed. And what that does, and in fact, in order to get that benefit, we have to go through a whole process, and let me just explain it briefly. In order to apply for the court for late permission to file a late claim, we have to obtain all the medical records. I then have to go through each one of those medical records, and then I have to send the records off to one of my medical experts who has to confirm liability, causation, and damages. Only then are we permitted to go ahead, and now I have to get an affirmation from the expert who says, I reviewed all the medical records, and it's my medical opinion, my conclusions, that there were departures from good and accepted care that resulted in the following injuries. So now we take the expert's affirmation, we take the application, submit it to the judge, and we say, Judge, listen, we'd like you to approve this process so that now our client can go forward and bring a lawsuit. Clearly something was done wrong. Here's what the court looks at to determine whether or not they are going to allow this to happen. Number one, they want to see that we have confirmation from a medical expert that there is a valid basis to proceed forward. Two, they want to see why. Why was there a delay? Is it a delay of a few days? Is it a delay of months? Is it a delay of a year? What's the reason? Is there a reasonable excuse for why there is a delay? If there isn't, you've got a problem. Now, assuming that there is a reasonable excuse, the court then looks to something which is remarkable. They say, is the defendant hospital prejudiced by this late application? And we, of course, say, of course not. They had the hospital records. Nothing has changed. The hospital turns around and says, hey, wait a second. The doctors who treated this patient are no longer employed. They're no longer working here. We have no idea where they are. How can we successfully defend a case or try to defend a case if the people who are treating this patient aren't here? In that instance, there's significant prejudice. And trying to get a judge to convince a judge that now you have the ability to go forward when the people who are working there are no longer employed, you're going to have a big uphill battle, a very challenging time. So, to answer that question, will you be successful in being able to get past the fact that your client came to you after the 90 days? The answer is maybe. But it's a long and involved process, and it's something that you will not know the answer to when they first come to you and tell you about this terrible tragedy.